Nanthakumar and others, and Morley.
Respondent.
Please, my lords, my lady, I appear for the appellant, and the appellant's generally been called KK in the papers. For convenience, the my learned friend Mr. Pearson appears for Morley's Fast Food.
Well, can I just inquire, because I had previously understood that you were going to be representing all the defendants, because of course some of them have a distinct interest, notably with regard to one of the grounds of appeal.
Yes. To that extent, I do appear for. I appear for their interests, so to speak, insofar as they are channeled through KK. They're not formally instructing brands.
Well, can I be clear about that? Because on the appellant's notice, they're all listed as appellants.
Oh, right. Okay. So I understand that the instructing party is KK, but that brandsmiths are instructed by them all through KK. So formally,
that's yeah, understood.
So just to be clear, you are appearing for all of them.
Yes.
Yes.
You didn't want me to read out their names, did you, by
No, no.
The appeal concerns the judgment of Her Honour Judge Melissa Clarke in the IPEC, the Intellectual Property Enterprise Court, and the appeal grounds are listed really in order of the judgment. Although you will have seen one of the points that we make in our skeleton is that it was a bit strange to not start with the settlement agreement, because if you looked at the issue of confusion and took account of what the sign was, the dominant sign within that analysis, it was perhaps more logical to consider the terms of the agreement first. But for convenience,
why? Can you explain that to me? Because how can a settlement agreement between two private parties affect the perceptions of the average consumer who knows nothing about the settlement agreement?
It doesn't affect the average consumer's perception, but what it does is it
likelihood of confusion is all about the perception of the average consumer.
Absolutely, my lord. The issue is that it tears a hole in the issue of likelihood of confusion, and that hole
So it gives you a defensive license.
It gives you a defensive license, effectively. Yes, that's right. But you could, but if
you don't need a defensive license if there's no likelihood of confusion in the first place.
Correct. But then the issue was that the judge founded the likelihood of confusion principally on the basis of analysis of the sign, which had been licensed. So if that's what's causing the confusion, it seemed a rather strange way to proceed. But I'm grateful for my lord's indication, because in fact what I propose to do is deal with things exactly that way. We say there was no likelihood of confusion. One didn't need to get into the issue of consent, and the judge was wrong, not only in the settlement agreement, in that respect, but also in respect of the franchisees. So what I thought it may be useful to do at the outset, given my Lord Justice Arnold's indications in previous cases, is to start with the Act and the essentials of the action before we get to the finer points. The first ground, if you look at the Trademarks Act, which you'll find in Bundle, Authorities Bundle, I'm assuming it's tab 1. Tab 22. Tab 22 of the Authorities Bundle, so it'll be volume 2. And that lays out the familiar scheme of infringement in section 10. And you've got identical sign with the mark identical goods or services, and for that confusion is presumed. And then you've got section 10.2. A person infringes a registered trademark if he uses in the course of trade a sign where, because the sign is, and it's B that is relevant, the sign is similar to the trademark and is used in relation to goods or services identical with or similar, and there exists a likelihood of confusion. And then section 10.3, I only mention the 1 and 3 because they're not actually in this action, because they establish the sort of parameters of the action. The person infringes a registered trademark in the course of trade using, in relation to goods or services, a sign which is identical with or similar to the trademark, where the trademark has a reputation and the use of the sign being without due cause takes unfair advantage of or detrimental to. Section 10.3 is not at issue in this case. And that's quite important because section 10.3 does not require confusion and merely making a link between the two, the mark and sign. And even if one were to establish the other requirements, that would not be relevant in this action. This is about a likelihood of confusion and nothing else. The second point to make is that when it comes to a likelihood of confusion, just by way of background, it's well established that there are different kinds, two principal different kinds of confusion. There's what's called direct confusion, mistaking one sign, mistaking the sign for the mark, and indirect confusion, where because of the nature of the sign, it looks like it might be a spin-off or a related company, a linked undertaking, and that's sometimes called indirect confusion. Just to be clear, that the judge's finding in this case was of direct confusion. There wasn't any suggestion that somehow getting up a completely different word in the same font and colour or whatever meant that people would think it's a linked undertaking. The whole analysis was based on the basis of direct mistake confusion, so to speak. Now, the important point when it comes to assessing confusion, of course, is the use of the average consumer construct. And I say average consumer construct because the words average consumer are a little bit misleading sometimes. Is it an average of consumers? And indeed, I noted that in...
The answer is
clearly not.
Now, no, it's not.
Clearly not. And I noted that in SS's evidence, he said our average consumer is sort of 18 to 32 or whatever. It's in the supplemental bundle, I won't turn it up. But he made the natural mistake of assuming that somehow we're talking about an average of actual consumers. But in fact, the purpose of the word average, the work that's done by the word average, is really to talk about the attributes of the average consumer. The word average gives colour to the word by focusing on the degree of care and attention and the amount of time they may spend at the transaction stage or the pre-transaction stage, the type of goods. It's a way for the courts to consider what sort of goods we're talking about, because of course high-priced goods, the purchase of a car or maybe investment services or something, there may be a much more careful and attentive consumer than there is for fast-moving consumer products, things bought at the checkout. So that's really the purpose of that. And I thought it might be useful just to look quickly at the authorities on this. There's just a couple of authorities. We've cited one in our skeleton, but I think it's probably most useful to look at the Schutz analysis and also my Lord Justice Arnold's analysis as well. If we look at, just find this, London Taxi is the authority that sort of sweeps up a number of these points. And that you will find at tab 9 of the first bundle of authorities. page 308. That's where I'd like to pick up the discussion. This case, on its facts, was a little bit specific in the sense that the products were London taxis, and the person who jumps in a cab and hires a cab is not purchasing the goods. And so there was a discussion about whether their perception was relevant, and obviously they were less attentive and careful than the taxi drivers or corporations that employ taxi drivers that would actually be purchasing these vehicles. And if I could pick it up at the bottom of that page, at 308, it's well established that many questions are to be assessed from the perspective of the average consumer, who's deemed to be reasonably well informed and reasonably observant and circumspect. Those words are important. You'll see that in all of the cases, and they are there's a baseline of reasonably observant and reasonably circumspect that applies to all goods and services. So there's no goods and services that you're entitled to say, well, they're not reasonably observant and reasonably circumspect. But here we're talking about, this is really on the issue of who is the average consumer and are there classes of average consumer. Now, this was explained, as Lord Justice Floyd refers to, in the Interflora case. At the bottom of the page, this court considered what was meant by average in the context of the average consumer in its judgment in Interflora. And Kitchenell J explained that average consumer is not some form of mathematical average, rather the average consumer was a notional person whose presumed expectations are to be taken into account by the National Court in assessing the particular question it's called upon to decide, and that's because one sees the concept populating all of the provisions of the Trademarks Act. Comes up in revocation and validity and so on as well. So really that's the presumed expectations, which we mean attributes, really is about the size of it. Now, there's reference to a couple of European cases there, which Lord Justice Floyd did not find particularly helpful, but then he refers to some of the English cases, and he does find one in particular quite helpful, and that is Briggs J, as he then was, in the Schutz case. And if you see the passage just at the top of 311, the test requires the court to identify the relevant perception of consumers within any relevant class who are neither deficient in the requisite characteristics of being well-informed, observant and circumspect, nor top performers in the demonstration of those characteristics. That is in substance what average means, and Lord Justice Floyd agrees with that. And that, in my submission, is a neat formulation because it makes it clear that whatever class you adopt, that class has to have those characteristics. They don't have to be nerds and top of the class, but they should not be deficient in the characteristics of being well-informed and circumspect. That case, as it happens, involved intermediate bulk containers that were sold to the trade and had some effect. Now, the key trademark issue, as it happens, how you identify a class of consumers is you look for any relevant consumer who is likely to rely upon the trademark as a badge of origin. And that was really the finding there. Although, to be fair, I think Lord Justice Floyd doesn't quite decide the point because he says that it may come up in another case. But that, in my submission, is pretty much a fair summary of the law. The lifestyle equities case follows a similar approach, and I think we've cited that in our skeleton, and that's my Lord Justice Arnold's judgment given in Court of Appeal. Just wanted to pull that. skeleton, tab 4, and you.
Tab 19 in the core bundle.
Tab 19 of the
Second core bundle.
of the supplemental bundle. The authorities, does bundle mean? Yeah.
Well, I think it would be helpful just to look at it in the authority.
Yes, yes. Yes. Sorry. Tab 19. Oh, helpfully my authorities bundles, this one does not have tabs. Does it have tabs?
I think it begins at 737.
My lord, I'm very grateful. The passage in question, I hope, has been sidelined. This was a case where the issue was about online purchasing, targeting on the internet.
Oh, in which case it's the wrong one. So
Oh, sorry, this is the court. Yeah, that's the other one. This is an appeal to the Court of Appeal following the infringement action.
So do you want tab 15? 613.
613.
Sorry, I thought you were talking about Raw County case. I thought.
Yeah, this is the one where you have the appeal from Mr. Justice Michael Green, Justice Arnold. Yes, and this one is about the internet purchase, and Lord Justice Arnold explains that the purpose of classes and subclasses is really just to highlight specific classes of consumer with specific characteristics. And if I could just find this passage,
Paragraph 54.
I'm grateful, my lord. So yes, it's highlighted. Thank you. The fourth question is the relevance of the perception of the average consumer. It's clear that with most questions concerning the use of signs in trademark law, whether there's been use must be assessed from the perspective of the average consumer, who's deemed to be reasonably well informed and reasonably observant and circumspect. Thus, one excludes from consideration those who are either ignorant or have specialist knowledge, and those who are either careless or excessively careful. But otherwise, one takes into account the characteristics of the spread, characteristics of the relevant class of consumers. Such consumers are not an undifferentiated mass, but have the spread of relevant characteristics that human beings have. To take a familiar example, some people pronounce certain words in different ways, and therefore one must take the differing pronunciations into account. In the present context, one must take into account the fact that consumers have differing attitudes to purchasing goods from foreign websites. Some are averse to the idea, some positively want to purchase goods from foreign websites because the goods they desire are not readily available, and many others have probably never thought about the question. In the context of the case law, other case law, various classes of consumers have been found. Those who are potentially familiar with a sport or something like that, they'll know what the meaning of a particular piece of equipment is from that sporting field or so on. An average consumer comprised of specialists, doctors or whatever, will know what that surgical tool name is. And so it does come up as a reasonable thing. And we say that the judge was fully entitled to look for classes of consumers. But it has its limits. One does not go into an exercise of salami slicing that results in a class which really has no concrete characteristics. There must be some reasonable, legally certain basis for defining a class of consumers in order to adopt the perspective of that class to the exclusion of others. And the reason this is important is because, as a matter of analysis, when it comes to trademark infringement, the claimant only needs to show that there would be a significant proportion of the public confused. So the fact that you can show the majority of people would not be confused if you're the defendant doesn't help you. So the alighting upon a specific class is an important part of the approach. Now, we've set out in our skeleton how we say the judge approached the matter of class. And it may be useful to just look at that. I've sort of set it out in a tabular form on page 27. So there are two aspects to this first ground of appeal. The first of them is misidentification of class. The second of them is misidentification of attributes. But looking first at the class issue, consumer A, notional, so to speak, the first subdivision was to take from the general public to whom the trademark monopoly is addressed and focus on the respondents, actual customers. Now, it might be that that's not the biggest error in the world because they may be likely to be coterminous with the public for the public addressed by the trademark. But it is the first level of subdivision. Then what the judge does is she divides further that group into daytime customers and nighttime customers. Now, that is a strange thing because on its face, they appear to be the same customer. They're the same people, or at least they overlap to a very considerable degree. If I can just show you that. The part of her evidence of the judgment where the judge is dealing with this, So who is the average consumer of the claimant's goods and services? At 74, page 74 of tab 4 of the bundle, paragraph 74. This is the adoption, these are the submissions, and then in 79, the determination. In my judgment, there are two classes of average consumer to consider in this case. One is the class made up of children, young people, students and families who buy at lunch at tea time and into the evening. Well, young people and students, and potentially some family members, but certainly children, young people and students who are buying at lunch and who are said to exercise a medium to low degree of attention. If one looks at the second class in paragraph 80, the second class is the late night and early morning revelers, described by SS, who are actually tired, who are likely tired, hungry, and a significant subset of which will be intoxicated. Now, these are presumably young people who are likely tired, hungry, and a significant subset of which are intoxicated. So that's a subdivision which doesn't really seem to make a great deal of sense, we say. We say that the subdivision, if you look back at the table, we had a division into daytime and nighttime customers, which was somewhat arbitrary, and then a division of nighttime customers into the ones before 11 p.m. because most Morley stores close at that time, and then the late night revelers, and then a subdivision of those into the sober and the drunk. Now, I'll move straight on to the second point, the point about attributes.
Just before you do, I mean, is it quite fair to have all these subdivisions? I mean, if you take, say, your subdivision into those who are sober and those who are drunk, do you really get that from paragraph 80?
80 excludes someone who's just come home late from work.
Or does it?
It seems to be. Well, sorry, does it exclude? It divides, let us say. That's the only point I'm trying to make. So there are, in that group of nighttime people, there'll be Uber drivers who may be starting their shift and hungry, or there may be someone who's been working late in the office who's picking up a burger on the way home, and any number of other people. And then there's another group who are likely tired, hungry, and a significant subset of which will be intoxicated. So just to focus on the attributes for a moment, we say that it is not legitimate to adopt the perspective of someone who is intoxicated. I say intoxicated because the idea, the way that this is deployed by the judge is as an effect on their perception of the sign. And for intoxication to have an effect on perception rather suggests that there is quite a high level of intoxication. And that, in my submission, is not a proper attribute of the average consumer.
Well, do you say that's just because the average consumer has to be observant and circumspect?
Yes.
And someone who's intoxicated?
Well, intoxicated...
Even if the majority of actual customers were, for the sake of argument,
yes,
I think you're saying...
That would not be a legitimate starting point, any more than it would be legitimate to take the perspective of someone who needs glasses, not wearing their glasses. It's just not, it's not a deemed attribute.
And just staying with that a moment longer, you say, well, the judge attached significance to that. Where does one see that?
Yes, that one sees that actually in the key findings of the judgment. You can see that when she comes to the assessment of the likelihood of confusion. This is one of the key factors. If you pick it up at 83, paragraph 109, I have the relevant principles in mind and assess the likelihood of confusion through the eyes of each class of average consumer, taking account of all relevant circumstances and the context. And then 111.
Sorry, paragraph 111.
111 over the page. The judge doesn't find this a difficult decision to reach. This is not a marginal decision. And factor one is a class of average consumer made up of late night revelers, a subset of whom are intoxicated and who pay a low degree of attention to their choice of fast food stop. Actually, that also goes to my Lord Justice Newey's question about subdivision of the evening people. So she talks about them in terms as a subset.
One struck out the words a subset of whom are intoxicated.
Yeah.
The conclusion would still stand, would it not?
The wrong conclusion would still stand, and my submission would still stand. Yes, it's the class really, I suppose, is not the key or the most important error. But there comes a point where, in trademarks, you could keep salami slicing until you get down to whoever you want to, really. And the only submission I make on this is that it has to be some reasonable reflection. A trademark is a public monopoly addressed to the world and enforceable against the world. And there has to be some reasonably representative section of the public that it is said to operate on in terms of causing confusion.
Can I just ask that question again, if I may? Because
yes.
I think you said the class isn't the major problem. Are you saying that the judge's conclusion that the average consumer would have paid a low degree of attention is undermined?
Yes, because
And how?
Because she links in that paragraph 111.1 the a subset of whom are intoxicated and who pay a low degree of attention. So that is linked. It's linked to their attentiveness and their perception of the sign.
Can I put the same question a different way? If you go back to paragraph 79, this is the first class identified by the judge.
Yes.
I appreciate your basis that she was in any classes at all, but never mind. The purpose of this question, let's just focus on this class.
Yeah.
Because one sees in line 5 that she assessed the first class as having a medium to low degree of attention.
Yes.
Now, is it your submission the judge would have reached a different conclusion on likelihood of confusion if she had viewed the matter from the perspective of a class of consumers with medium to low attention as opposed to low?
Yes, it is.
You say that makes all the difference.
It does make all the difference because it's not only the degree of attention that comes in. The judge says low degree of attention for the average consumer who are intoxicated. And there's obviously a difference between medium to low and low.
Even on that, and going back to 111,
Yeah.
Are you being fair to the judge, do you think, in saying that it's only that it's the feature of intoxication that results in a low degree of attention? I mean, she recognises it's a subset. There are lots of other people who are rushing into they're tired and hungry.
Yes.
They're rushing in to grab a burger before the place shuts, perhaps.
Yes.
She's not saying it's only those who are intoxicated who are paying a low degree of attention.
Well, the only subset that she mentions there, that she identifies, is the ones who are intoxicated. And that's factor 1. So had she then gone on and said, and I find that a large portion of other people would also paying a medium to low attention.
Well, isn't that inherent in paragraph 80, where she's identified her second class as the late night people, a subset of whom are intoxicated? They, presumably meaning all those people,
Yes.
pay a low degree of attention. So the whole class will pay a low degree of attention. And she says, well, if you take people who are paying a low degree of attention, then they're likely to be confused.
Well, yes. The difficulty here is that, of course, there didn't seem to be any evidential basis for the intoxication finding at all. This was said to be based upon SS's evidence, but she quoted SS's evidence early in the judgment, and all he said was that a significant number had been out drinking and enjoying the local nightlife. Didn't actually say they were intoxicated, still less to the extent that their vision had been impaired. But I think perhaps the way to...
Sorry to interrupt you, but I think it might be helpful if you could articulate for us what you say the judge should have concluded as to the relevant class of consumers and their degree of attention.
So on the authorities that I showed my lord and lady a moment ago, every consumer, or the notional, every consumer in every case, I mean, so every time the court adopts this notional construct, it must hold that even with a low degree of attention, they are deemed to be reasonably careful and reasonably circumspect.
Well, we take that as read, that's the law.
Yeah.
But we still need to identify the relevant class of consumers and their degree of attention on the facts of this case.
So there was one class of consumer who visits late at night, very early in the morning, 1 o'clock in the morning, and even at lunchtime, and those are young people, young people who are perfectly good class, subclass or subset. And obviously they have a range, as Lord Justice Arnold said in the lifestyle equities case. They're not a sort of indeterminate mass. Some are a little tipsy, some are in a bit of a hurry, some are not. but the court has to come up with some appropriate construct. And of that group, those young people, they have to be exercising reasonable care and attention to find this chicken shop and find something to eat. That's what she ought to have found, and what she.
So what I've written down, and tell me if I misnoted your submission. Your submission is that the relevant class of consumers in this case is young people exercising reasonable care and attention.
Reasonable care and attention, yes.
And is reasonable for consumers of these services and goods high, medium, or low?
We would be. I've always found those personally those degrees that are sometimes used in the judgments a little bit sort of tautological, because you can have a low degree of attention and be confused. You know, a low degree of contention and not be confused. It just depends. But if you...
Well, the general assumption in the case law is that those who pay a low degree of attention are more likely to be confused than those who pay a high degree of attention.
Yes, exactly. But this was another attribute that was layered onto the degree of attentiveness, which was...
I'm still trying to find out what your case is.
Right. So...
Is your case that the relevant class of consumers will pay a high degree of attention, a medium degree of attention, or a low degree of attention?
We would accept the characterization medium to low. So you don't have to sort of, you know, if we're going to be adopting these gradations, we'd say medium to low in the same way northwest. So between the two. And because that is the factual finding of the judge in relation to that class in general.
So does
So
it
they
come
challenge
to,
that.
Does it come to this? When we really get down to the nub of it, your criticism of the judge is that she viewed matters from the perspective of her second class of consumers and not from the perspective of her first class. If she viewed matters from the perspective of the first class, you would have no quarrel.
That's correct. Although, you know, the first class also includes mums and people who are likely to be perhaps more at the higher end of care and attention. That's perhaps because that itself is a somewhat artificial breakdown. It includes consumers that are very different from each other. And that's why I adopt young people generally exercising a medium to low attention span. But that's the basis of what we say a finding should have been. But what the judge did then is say, I'm going to take that group and I'm going to imagine that they've been drinking first.
Sorry, I don't understand.
I'm not the only one. They've been drinking and they are intoxicated. And there's a difference between having a drink and being intoxicated, my submission. And the judge...
Yeah, well, I think we've got your point. She was wrong to take that into account.
And another problem with intoxication, of course, is that there's just a range of intoxication. You know, the level of intoxication to impair your actual vision, if that's the assumption, is actually quite a high one, we would say. And that is not legitimate in any way. So, let me just... The first ground is really that. And we don't need, I think, to trouble you more with that ground. According to my notes. So did you have something you want to add? Oh, the low cost of the relevant business. Yeah, but she rejected. Yeah. I was going to just show you just one last thing, actually. The reliance on, I mean, I hope I've quoted correctly from the evidence from SS, but his witness statement is in the supplemental bundle. And you'll find that. Yes. behind tab 2 of the supplemental bundle. And he deals with this highlighted.
So paragraph 29.
Correct, my lord. Yes, Morley's average consumer. This is the point I made earlier about the average consumer being configured as a sort of statistical average. Is aged between 13 and 32. The majority are school, college and university age, because they have less disposable income and our food is relatively low cost. It's always been a place for people to meet up. There's a spike of activity across all Morleys around lunchtime, tea time, and once again later at night. Most stores operate from 11 till 11, but some stores have a late license operating into the early hours. Such stores see a significant amount of custom from people who've been out drinking and enjoying the local nightlife. Well, yes, you can enjoy the local nightlife without getting completely blotto, in my submission. And that's not what he's even saying. So that submission, the point about intoxication seems to have been one that the judge, either it was made in submissions or the judge came up with it, and we say it's not a proper basis. So let me turn to the second ground, which is the visual comparison. We say, by the way, my lords, you will have seen from the outset of our skeleton, we say that the errors fall into one of either two camps, rationally insupportable in terms of being findings of fact, or errors of approach and analysis, principle rather, when it comes to the multifactorial assessment. Sometimes it's a little difficult to keep those two things completely distinct because one is looking at an overall conclusion that might be said to be rationally insupportable. But then you go back and look at the multifactorial comparison and find that there is different weight or wrong approach being given to things. And then you find an error in the conventional sense. But then individual findings might be rationally insupportable as well, but get plugged into the multifactorial analysis. I just say that because I have to say it's sometimes difficult to put them into the right pot. So if I could just step back for a moment, the judge held that just take the signs in question. Tidy up if I may, just a second. Now, the judge set out the signs in the judgment, and there's an immediate question, first of all, as to sign 1. I don't raise this as a formal point of appeal, but sign 1 is shown and defined in below paragraph 2. Sorry, that's Morley's. And you've got Metro sign 1 below 11, and you've got the settlement sign below 9. The significance of what was called sign 1 in the particulars of claim is that it appears to be a trimmed or cut down version of the actual sign used. So that is the claimant's formulation.
Well, I'm not sure that's right. I mean, there's a problem which I'm sure is not of the judge's making.
Yeah.
Is evident with her description of the sign, particularly when we come on to the settlement agreement. Because it's clear from what she says in her description of it, the sign 1 has a border which is not apparent in the image.
Exactly so. And that's why
she was clearly fully conscious of that because she describes
exactly
in the text.
Now, I checked with,
So can you show us an image that shows it
in its full glory.
in its full glory? Thank you. Those were the words I was looking for. Thank you.
I will show you it now. That's in the supplemental bundle, and you'll find it. There's a number of franchise agreements. I think you can take any of them, but just to take page 166, that's an. Well, I'll show that in a minute. What page is that? Yeah. So the 166 of the supplemental bundle, that's an example of the franchise agreement, and that's when
Yes, but
I'm going to show you. I'm going to show you a
that doesn't
picture of.
show you how it looks in real life.
My learner junior just showed me that one, and I'm going to show you that now. This one's quite good in terms of just seeing the detail of it. You can see the three borders, the three lines, and the missing lower border. You can see the slogan or the strap line, and the word metros. And then on what page is that? 339. Yeah. 339, you'll see a picture of the sign in use. 337, is it? Rather than 339? Okay, yeah. Just, it hasn't got a page number in my one, that's all. It's behind tab 6 or 7, if actually you were to look at a three-dimensional version. It's got the burger on it, hasn't it? Yeah. So that was the fascia of which the claimant complains, but when it came to the particulars of claim and the judgment and the definition of the infringing sign, they zeroed in on the word metros and it's the real taste. Now, I say that just for the sake of administrative clarity rather than anything else, because we say that the visual analysis based on that alone was also erroneous. Now, if I could just continue with the analysis that I started with, which is you've got a 10-1, 10-2, 10-3 scheme. You've elected 10-2. You've considered the average consumer. Another part in your analysis is to consider the visual, oral, and conceptual similarity between marks. Now, this is potentially the most important factor. It's not, one can't say that it dominates all other factors, but only because the directive originally says that it's because of the similarities between marks and signs there exists a likelihood of confusion. Now, case law has inserted a number of other reasons and factors into that analysis, but the statutory basis is similarity, causing
Well, on
confusion.
2 dimensions, not just marks and signs, also
And goods, yeah. And here the goods and services are identical, and it's important because, as Lord Justice Arnold just mentioned, the similarity or identity between goods can offset similarities or dissimilarities between marks, and vice versa. So that it all goes together. But visual comparison is obviously the usual starting point. Just to make some observations about the trademark, which you'll find compared to this earlier in the judgment, the top of page 54. And the sign 1, the bottom of page 55. Those are the two signs we are comparing. The first, I'm not going to just suggest that the judge got things wrong by considering failing to give weight to certain points or anything like that, but I just wanted to make it very clear that these are word signs, word marks. They are not, as one often sees, a compound or composite mark comprising a device aspect, whether it's a distinctive one or not. So, for example, the
I'm not
Starbucks.
sure I entirely agree with that, because first of all, these are stylized word marks, and secondly, they include colour.
Yes. So I hope I'd said that they're stylized words. They're definitely stylized. There's no doubt about that. But they are still, in terms of semantic content, they are words, stylized and coloured. And that is really the first problem with the judge's visual comparison, which I'll show you in a moment, was that when you have, let's say, a composite mark, let's say a sort of a Nike plus the swoosh, or you have Starbucks plus the mermaid device, obviously those pictures have some semantic significance, semiotic significance. They have significance as a sign with meaning in some cases. But that's not the case here. We're dealing with fundamentally words. And in my submission, when it comes to the visual comparison, one has to take full account of that fact. The other point to remember about words, and these are just general points, this is not a rule of law, but it is certainly true that consumers read from left to right in most European languages, and I think all, and that means that in general, courts place importance on the beginnings of marks. So the M, the similar M, might be said to have some significance by that approach, but equally the three M's in the strapline, to the extent that the strapline is perceived, and this is quite important in the visual comparison made by the judge, that's important when it comes to the strapline, the beginnings of the strap, the first letters, M, M, M. Now, just to outline some impressions from this, and I don't think the judge found that the fonts were identical, but they're clearly not. I mean, the Metro's word is not joined up, apart from anything. The writing is not joined up, whereas with Morley's it is, and it's obviously a cursive font. They're both similar to that extent, and they're both in red, white letters on red. So there's that point as well.
So you would accept that there's a very considerable similarity in terms of the capital M at the beginning of each word, and also the apostrophe S at the end.
Yes, there is a similarity between those two aspects, but that, in my submission, is at a very broad, very high level of generality, of visual, a generality in the visual analysis, because a word exists to be read. It's meaningless if it's not read. And as I'll come to in a moment, well, I'll come to it when I get to the settlement agreement, there was, the actual word was deemed to be non-confusing under the settlement agreement.
Well, I don't think it goes that far, does it? There
Well,
was no license to use the word Metros per se.
there was no license, but in my submission, it wasn't a license at all in any event. I'll come to it, but it was a release. It was a release of claims in relation to Morley's. And it was said to be unobjectionable that one uses Metros. And the picture of the settlement sign contains that. So clearly that was part, or should have been, part of the consent.
But in the event, as we agree,
I'm coming back to
this
this.
is a subsequent stage of the analysis. At this stage, we're looking at the perceptions of the average consumer.
Perceptions of the average
Your point is a simple one. You say Metros is a different word to Morley's.
Correct. And we say, irrespective of the visual similarity, which we accept there is some, it has to be given appropriate weight. The judge mostly gave it appropriate weight when it came to the main sign.
So where's the error of
The
principle?
error was in her failure to actually take account in the visual analysis of the word. Now that is a surprising thing to do when you're dealing with a word mark stylized word mark being compared with a word, stylized word sign. If I could just pick it up at 79, the judge actually dealt with visual, oral and conceptual together in the ensuing 2 pages. But if you look at one has to look at the submissions made because the judge agrees with all the visual similarities so of the claimant. So issue 4 is sign 1 similar to Morley's red and white, page 79. The claimant submits that both are visually highly similar. Both use white lettering and an identical or highly similar red. Sign 1 uses identically the distinctive form of the letter M as the first letter of the main word. The layouts of sign 1 and Morley's red and white mark are highly similar, being a main word with a highly similar structure and highly similar larger font set above a strapline. This is a sort of layout similarity, and the use of a similar strapline with shared elements, it, taste, and an ellipse, conveying a highly similar concept. That's come back to conceptual similarity. Then there are the defendant submissions, which, as forceful as they are, I will not read out because they were not followed. Now, 96, I agree with all the visual similarities identified by the claimant set out above.
And she goes on, the dominant element of each of sign 1 of the Morley's
Is the brand name.
Is the brand name. So
Exactly.
she didn't ignore the word.
Well, yes,
On
but
the
then
contrary, she regarded it as the dominant element.
yes, but then if we go on, which although different, do present similarly with a closely similar but not identical font, the almost identical large stylized M being the most dominant part of that dominant feature, I find that the font used in the large stylized M to be distinctive. Now,
Wrong about that.
so what the judge has done there is she has noted that the dominant element is the brand name and has noted that they are different, but that has not played any part in the visual similarity or the weight of similarity or difference. It is given no weight, at least none that I could see in the ensuing parts of the analysis. I mean, she's noted it, but it is not said, well, despite that, I find that to be outweighed by other things. It's simply given no weight. And of course, in the submissions made by my learned friend that she visual submissions that she agrees with, that's not mentioned at all. So it doesn't come in that way.
What about paragraph 102?
That's conceptual. I'll come back to conceptual. I'm dealing purely with the visual because
But again,
and that's
she
important.
deals with the names in 100 from a visual perspective.
Despite the different brand names in the dominant element, the differences which are made somewhat less significant by the almost identical dominant stylized letter M, very similar font and word length, and the missing triple M. Now, what happens in this part is that
So
the strapline.
The overall conclusion on visual similarity is they're visually quite similar, but in reaching that overall conclusion, she's taken into account the difference in the brand names.
that is where we come to rational insupportability. Because what happens
You
here?
can't point to any error of principle in her approach. Your submission is she's just plainly wrong.
Well, this ground is headed in our skeleton rationally insupportable. Visual analysis. And what she does is she finds overall similarity. I probably need to just go back up to 97, 98. 97, the strap line of each, although not dominant, is by no means negligible. And I find in each case that it's an important secondary element which has a distinctive role. So it has an independent distinctive role, it has some distinctiveness, and it's secondary to the main dominant element. The placement of that secondary element is dealt with in 98, and it's said to have the identical italic serif font and the ellipse add to visual similarity. And then she notes that the MMM in the Morley's red and white slogan or strapline is a point of difference. That's the point I mentioned earlier about it being at the beginning of the strapline. So also adding to visual similarity is the use of white text on red, and I accept that those colours are not distinctive in this fast food arena. I accept Mr. Pearson's submission that the similarity in font size and layout produces a pattern white on red, which is visually very similar and adds to the distinctiveness of the whole. So, and in 100, which is the paragraph I was just taken to, despite the different brand names and the dominant element, the differences which are made somewhat less significant in my judgment by the almost identical dominant stylized letter M, very similar font and word length, I find that Morley's red and white mark to be visually quite similar. Now, that we say is rationally insupportable, wrong, because these are stylized words. The judge herself has acknowledged that red and white is very common in the fast food business, most importantly used by KFC, that Mr. SS acknowledges the whole Morley's business was based upon, and that is used by chicken shops and fast food establishments commonly. Secondly, it was found to be visually overall based upon the strapline. And I wanted to just look a bit closely at that, because the strapline, it can only be the placement of the strapline that was similar rather than the content. Because first of all, if you look at the two straplines, one is, it's the real taste, it's my client's, and the other is, I'll come back to conceptual in a minute, I'm just talking about as visual, as a series of letters, so to speak, and words that mean something as well, but words that get read, they are not visually the same at all. There isn't a letter in the same position. The words are all different, and they lack the triple M, and that's said to do the work of toppling over the difference between the dominant aspects. And we say again, that's rationally insupportable. It's rationally insupportable for another broader reason, which is that slogans and straplines don't usually have any distinctive role. They're just considered to be marketing statements. It's very difficult to register a strapline or a slogan, as many parties have found out, because essentially they're just, they're not really picked up on by consumers. They may be read or regarded as important in terms of the values of that particular business, but as a badge of origin, they just don't play a main role. Visually, looking at this configuration and thinking of this as on the front of a fascia. So if you look at the page we looked at earlier, the picture of the fascia, like this, it's very difficult to see that that would be read and regarded as visually similar.
But in terms of fascias, I suppose you can compare 338 to 339, can't you? Tab 5 with tab 6.
So that is, yes, exactly. I mean, it's the same size and length as the sort of description of what you can buy there. It's quite clear in my submission that as visual analysis and as words, these two strap lines don't bear similarity individually, and then nor do the words, and the judge is effectively squinting and saying, well, looking at these as pictures without reading any of the content, as if it's sort of pictograms or just marks on a page, they are similar. Well, that's not the right approach.
Well, just to understand, is the ellipsis relevant?
The ellipsis, my submission, I couldn't actually find the ellipsis in a lot of the photographs. It isn't, no, it is not relevant. 3 dots are barely likely to be noticed by anybody.
And you also get the words taste or tastes.
Yes, it's actually not even the same word, but there is reference to taste and tastes. Yes. These are food products. They're marketing statements. That just reinforces the marketing exhortational value of these slogans rather than their distinctiveness. These are likely just not to be even, you know, they're not likely to be given any importance at all by the consumer. It's important because in that paragraph that I took you to at the end of that section of visual similarity, it is the slogan that ultimately does the work of finding similarity, overall similarity. The next point, let me check the note on this. The visual analysis is probably, well, it's important, but it's not to the exclusion of the oral or the conceptual. Now, the judge did go on to find that there's no oral no oral similarity, and obviously it was right to find that because the words spoken would not be similar at all. I mean, that would fail. Then we've got to, and that can't be left out of account because that's part of the overall assessment. The next question is, of course, the question of conceptual similarity. Now, the conceptual similarity is dealt with in the same section, and my Lord will just really took me to that passage. 89, I do not accept the defendant's submission that the sorry, let's see this one. Thank you very much.
102.
Yes, I've gone forward. Thank you. 102, conceptually the brand name Metros within sign 1 is not similar to Morley's in the mark. However, I find sign 1 and the mark to be similar conceptually overall because of the conceptually very similar straplines centered around good taste. Now, first of all, again, the judge has wrongly approached the matter, deciding confusion based upon a non-negligible element, which we say is of extremely low prominence within the sign and mark, and is likely to be a very low distinctive value because of the nature of slogans. But conceptually here, we say that the judge ought to have considered that the marks conceptually counteract. And that's an important principle.
Oh, I'm sorry, Mr. Manage. If you're going to go into conceptual counteraction, which is not a ground of appeal and is not mentioned in your skeleton argument, the very least you have to do is to cite the relevant authorities on that question.
Let me just take my skeleton, because I don't think we fully argue it as conceptual counteraction in accordance with the case law.
Well know that
Yes.
it's a very specific
Yes.
doctrine of the case law from the Court of Justice, which has very specific requirements.
Yes, namely that there be...
Can you possibly contend that the requirements of the case law for conceptual counteraction are satisfied in the present case?
I meant to say that the conceptual message conveyed by the marks is different, rather than that there's a conceptual... But my Lord Justice Arnold is referring to a line of case law where the two marks, for example, there have been various German cases and various cases, but where the two marks mean completely different things, even and clear, and that's clear to the consumer, even though their visual and oral similarity might be quite high. And so it's a sort of trump card operating against the likelihood of overall confusion. we don't contend that. All I do is attack the judge's assessment of conceptual similarity. And I say that was rationally insupportable. And I say that because Morley's,
Again, you talked earlier about wrong approach, but you're really saying she wasn't entitled to
this
it.
one is wrong, this one is rationally insupportable, yes. And I apologise if I'm mixing up these two concepts from time to time. It's not always easy to keep them apart. But Morley's has a synonymal significance. It's seen as a name, quite a common name actually, but whatever. It's a name. Metro's is not. Metro's is, well, the possessive gives it some sort of entity significance, but not really as a name of a person. That's the first point. But actually that doesn't matter because the judge didn't take that into account. But perhaps I need to attack more directly the slogan.
Can I just ask you about that? Are you really relying on the proposition that the average consumer seeing one of your clients' fascias would think of Underground Railways?
No, not necessarily. I think the way we describe it in our skeleton is something to do with the city, metro, something to do with the city, something urban.
Why is there an apostrophe S at all?
Well, exactly. That's a fanciful element for that. So it does make it into an entity which has establishments or a range of establishments, yes.
The average consumer would take it to be a name, wouldn't they?
They'll take it to
Not
be...
necessarily a name of a person.
That's right.
But nevertheless,
Yes,
a name.
I think I would accept that. They would take it to be a name, not necessarily the name of a person. And that's why I guess we don't rely on conceptual counteraction formally in the strict sense, because that really does require a very clear and concrete meaning, and I can't contend for that. But what I do say is that's not similarity. Then when it comes to, it tastes better, compare that, so that's the trademark, and just focus on that for a moment. The judge held that they were similar because they both convey associations of good taste, accepting my learned friend's submission in that respect. Well, at that level of generality, perhaps, but that is not in any way a fair reading of the message conveyed by the slogan. As the judge rightly held when it came to the family of Marx assessment, if you look at that in the judgment, when she dismisses the family of Marx argument, she actually finds, we say quite correctly, M would be, that slogan would be seen as an expression of satisfaction. Someone saying, expression of delight. It tastes better. I would, so she deals with that issue, there's no appeal on this ground, but yes, it's issue 1, page 75, and the determination of that is 86 to 87. It's here. Yes, it's 89. 3 lines down. In my judgment, the M in Morley's red and white mark, found as it is in the context of the central strap line, is likely to be seen, pronounced, and conceptually understood as one long sound, as the familiar expression of pleasure in something tasty. And that's what.
So where's the inconsistency?
So, no, I'm relying on that. I think that's...
I'm sorry, it may be my fault. I had understood you to make a submission that the finding on conceptual similarity is in some way inconsistent with her finding on family of Marx.
Well...
I'm struggling to see the inconsistency.
Yes. So I rely on the understanding or the analysis of the judge there, because she's saying there that that will be read and understood that way. And that's the conceptual message conveyed by the strapline, Claimant strapline.
Something tasty, but why is that inconsistent? That's the same concept as she says is conveyed in the
Well, just-
context of the conceptual.
Just pausing there for a moment. It tastes better. So there's a comparative aspect of that as well. It's better than some unknown competitor, potentially KFC, I don't know. But it tastes better. That is how the judge conceived of it, that particular slogan. Now, if you just look at the slogan adopted by Metros, I mean, apart from the concept of taste, it is not the same at all. It's not the same message. It is about authenticity. It's the real taste. And that, in my submission, is not, well, one could say that there's conceptual similarity at the most general, in the most general and descriptive sense. But I wanted to show you some authority on that, because one has to be very careful when it comes to conceptual similarity in attributing conceptual similarity to features of a trademark which the consumer would consider to be wholly descriptive in any event, and therefore look for small differences.
Just before you do, you say the Metros one is about authenticity.
Well, it's the real taste. It's a bit like the Coke,
Yes,
the
but
real thing.
isn't the message it tastes better?
Um,
I mean, authenticity. I mean, if it's authentically horrible, that's not much of a recommendation. It's,
That's certainly the case. There is, my submission, a subtle difference, well, not even a subtle difference, quite considerable difference between these two slogans, which are non-distinctive. It's really important that the court understands that that is the starting point in trademarks law when it comes to slogans anyway. So the judge was using this as a way of finding overall conceptual similarity. One would expect there to be a high degree of similarity between these two aspects. Visually, there is none, apart from it and taste. And they're different words. It's its and tastes, and they're in different positions, and they have other words next to them. But when it comes to conceptual, this is a promotional statement that is simply talking about the taste of food products. I mean, what else will a promotional statement for food and restaurants?
But I'm sorry, that seems to be conflating two different questions.
Yeah.
The first question is whether there's conceptual similarity at all. And I do not understand it to be in dispute as a matter of law. If you don't say it is disputed, tell me that descriptive conceptual similarity is nevertheless conceptual similarity. The question then is a different one, which is what weight that has when you come on to the next stage of the analysis, which is likelihood of confusion.
Correct. Yes, I would accept that completely. And that was the basis of the authorities that I was going to show, my lords. And I think probably I don't need to in the light of that the intervention, because we say, obviously, if you have two completely descriptive marks and you're just comparing them, at the stage of the comparison, they may be identical or almost identical, but then that still doesn't get them home at the likelihood of confusion stage, because the small differences may make a difference, or because the consumer doesn't attribute anything to that. But this finding here, this ground of appeal, is actually attacking the judge's assessment of conceptual similarity. We would say that there has to be some basis for looking whether they actually convey the same concept. And in this field, they do not. They don't convey.
Sorry, you said earlier there was conceptual similarity in the most general sense.
At the highest level of...
Saying that the judge was wrong to find that there was any conceptual similarity.
I think I have to accept that at a high level of generality, there is some conceptual similarity.
Okay, but then doesn't it just come down to weight?
No, because the judge regarded this, well, yes, I suppose it does, but the attribution of weight to that is not supportable, because ultimately the judge stands back and finds overall similarity because of that factor, and that, we say, is not rationally insupportable. So maybe, I suppose, it comes down to this, that when it comes to the overall likelihood of confusion, that it can't be said that's rationally supportable, that that was sufficient to make the difference in the overall analysis. In the light of there being no similarity whatsoever, conceptually, between the dominant aspects, apart from anything, and then when you looked closely at the strap lines, there was only the most general level of similarity. I hope that answers my lady's question.
Okay, does that take us on to the next ground?
That does. Context is the next ground, and for that, it's difficult to say what that adds to the debate, but we have the additional issue, which is that in lifestyle equities, my Lord Justice Arnold said that this line has yet to be clearly drawn in the case law, and I think when we pleaded this ground, we were hoping that that had been clarified by then. It's quite difficult to say that the judge was clearly wrong on context in the case of a very evolving point in trademarks law. So I think we probably don't have a lot to add to that ground.
Okay.
To what's said in our skeleton. I mean, if my lords have any questions for me, I'm more than happy to assist, but so it's not formally abandoned, but I don't wish to press it. So the next point becomes the next grounds, all of the grounds, the remaining grounds, relate to the settlement agreement. And if I could just introduce the settlement agreement a little, it is ultimately it's a release based upon previous trademark application and use by my client of Morley's, which somebody recognized at some point could be a problem, and they entered into a settlement agreement. The other background point is that there was at least one other franchisee known about by SS. And
Could you just remind us the judge's finding on that point?
yes, the passages on the settlement agreement are at the back of the judgment. As I say, the judge dealt with them last, and we can pick it up at one second. Sorry, it's broken up actually into two sections in the judgment. That's right. There's a section on the position of franchisees that the judge deals with first, and you'll find that in paragraphs, so it's issue 6, page 85 is the whole section. Now, there's a section on law, and then determination. If you see 120, there's a number of acceptance of the claimant submissions, and it's number 4. SS's evidence, which I accept, is that KK told him only one other person was using Morley's or Metros, and that was a man called Amin, who's not one of the defendants and is no longer a franchisee of KK. That at the time he signed the 2018 agreement, SS did so in the belief and intention that would only allow KK and Amin to use the settlement sign and no one else. So this, I can deal first of all with the question of whether this would have covered franchisees or would have allowed more importantly, actually much more to the point, would have allowed KK to sublicense. Now, the argument was put on the basis that this was an implied term. It went without saying, it was
It
obvious.
will matter for the purposes of your argument. But is it your submission that this is a finding? SS was aware that Amin's relationship to KK was that of a franchisee.
Correct, it is. Because he's no longer a franchisee.
Well, that's a statement, but he wasn't contemplated to be a defendant at that time either.
No.
So that's simply an identification of what Mr. Amin's current status is. I'm saying that's to be read as a finding that he was known to be a franchisee at the time.
At the time, yes. Yes, that's, we say, a fair reading of that.
Okay.
And I'm going to show you other provisions of the agreement that we say make it clear. Now,
Does it help to look at SS's evidence on this or not really?
it may do, although I think the judge was correct on her summary of this. Let me just, there's the settlement agreement, here we are. You can pick it up at 26 of bundle 2, page tab 2, supplemental bundle.
Seems to be paragraph
63.
63.
Yeah, at the time I understood from Kay that he was the only person using the Metro sign and that one other person was using the Morley's name. The shop using the Morley's name was operated by a man called Amin. Kay never informed me that he intended to franchise the Metro's brand. If he had done so, well, we say...
So that's an awareness that Amin was using.
yes.
Where is that
Right.
an awareness that he was a franchisee?
Well, that's how the judge interpreted it in her judgment.
Well, but did she? Because she certainly doesn't say that in terms. You're reading that into what she says.
If I could just zoom out and talk about sub-licensing, it may be that my point becomes clearer. We say that the question of whether this was a franchise or not was actually a bit of a red herring. Because what was envisaged under the agreement, known by SS, and specifically provided for, was use by others, licensed by KK. And whether they were franchisees or whether Amin was a franchisee, perhaps it's not important, although I know that franchising is a specific
for your
kind.
purposes, which is why, as I said
Yeah.
earlier, it doesn't seem to be necessarily that.
Yeah.
For your purposes, what's crucial is license from KK.
Yeah.
So, and I appreciate you saying the settlement agreement is not to be characterised as a license, but if it were, then conceptually the way it will work is there's a license from the trademark owner to KK and a sub-license from KK to third party.
Yes. And we see a number of provisions that, I mean, apart from the background matrix of fact there, we see specific provision, first of all, for KK to register a trademark for the Metros. Yes, I'm going to take you to that. It is page 188, behind tab 8 of the bundle, core bundle. If I could just, I'll take it from the beginning because of course then it'll be easier to make the submissions without jumping back and forth on both the main grounds. So if one looks at page 188, a dispute has arisen over the use in the course of trade by KK of the signs, so including the claim and IPO proceedings. And the signs, these aren't the Metro signs, these are the KK trademarks, Morley's, and any sign colourably similar. So this agreement was about stopping that. And the basic configuration of this agreement was stop that, you can do this. That's it, broadly. Now, there's some definitional terms, and most importantly, there is the definition of Metro's signs. Note the plural. It means Metro's fried chicken, which is an oddity in the agreement right away, because it refers to Metro's fried chicken, the logo, a copy of which is included at Annex A and any reasonable modifications thereto. But when you look at Annex A, which you'll find at the back of that tab, it's not Metro's fried chicken at all. It's another, it's the Metro's mark. It's got the words fried chicken there somewhere below it. And so that was the Metro's signs, and we obviously place quite importance on the words and any reasonable modifications thereto, which we say was an error by the judge in terms of the construction of that, or the meaning of that term. Just moving forward, there's a definition of related parties, a party's parents, subsidiaries, assigns, transferees, representatives, principals, agents, officers or directors. I don't think we don't rely on that specifically to cover the position relating to franchisees. The effect of the agreement is stated in 2 and 3. A signature, it's binding, and it's in full and final.
What do you say about clause 3.2?
3.2, for the avoidance of doubt, does not waive, release, settle, or in any other way compromise any claim MFF may have for parties' dealings in course of trade under reference to the signs. We rely on that. Why do I rely on that? Because the judge seems to have got confused over what is meant the signs. The signs there is Morley's. That does not reserve rights against Metro's users. That's signs defined as Morley's.
It's not limited to Morley's, it includes the KK trademarks.
The KK trademarks, yes, but that is not, that's the UK trademarks for Morley's. So that's not the Metro signs. We don't have those trademarks, do we? The ones defined there. Yeah.
I assume those are the ones in suit, aren't they?
No.
Apart from 311.
No, they're the KK trademarks.
Oh, I beg your pardon.
Yes,
I'm
the
getting-
KK trademarks. And that's important because the judge relied upon this as saying, well, essentially, this agreement reserves rights against franchisees, so how can it possibly be permitting it? But of course, that's a reference to the signs, which is the Morley's signs, and nobody doubts that that's what had to happen. That had to stop. That was the price of getting the Metro's sign. Now,
All right, but
further provisions that are,
even
sorry.
so, can I ask you this question? So as you point out, the definition of signs is KK trademarks, and you've helpfully clarified what that means. Morley's and other sign cover would be similar there too. But what's said against you is even on that basis, clause 3.2 makes it plain that there is no release in respect of third parties. So any third party, such as a franchisee, who carries on using the signs as defined, is open to suit.
The signs as defined, yes. So if they carry on continuing Morley's, this does not release them. That's what that clause is saying.
Even though it does release KK.
Does release KK. Right. So the position of third parties using Metros is of course dealt with in 5.6. And that is permissive to third parties. And we rely on that clause. Now, I'll show you where the judge dealt with this and what he said about it, but just if you could just read, he will make reason.
Can we just look at
Yes, I'm grateful, sorry.
5.6 and what do you say the effect of that is? So this is an undertaking by KK that he will make reasonable efforts within 14 days of the effective date to procure any third party using the signs, and we discussed that, what that means, in the course of trade to cease initial use and within a reasonable period to use in the course of trade the metro signs.
Right.
So, and then if they don't comply, KK will provide reasonable assistance and cooperation, etc., etc.
So that is saying if they continue with Morley's and they don't stop and replace it with the metro signs, then KK better cooperate to stop it. But what is interesting about this clause is that it envisages third parties using the metro signs, first point, and it also envisages, I apologise, no, just to finish the sentence, it also envisages that he has the power to stop them in some way, or he's related to them in some way, which means it's very likely to be licensees in some way, or franchisees. Otherwise, what business or power would he possibly have?
My initial reading of this is that it looks at what's going on around the effective date. He will make reasonable efforts within 14 days of the effective date to procure any third party using the signs.
Yes.
Does that not connote using the signs at that time?
Yes, absolutely. They want it done. They want it done sharpish.
It seems, and those people have within a reasonable period to use the metro signs.
Going forward.
Those people.
Those people, yes, exactly.
Using the capitalised signs at the effective, or within 14 days of the effective date. Not getting at other people.
Oh yes, this does not, I'm not saying this provides a specific licence to third parties going forward. What I'm saying is this is indicative of the claimant being content with third party use of metro, an unknown, unidentified body of people forever and a day being allowed to use metros going forward.
Okay, I'm not
But,
sure.
obviously-
I'm not sure that answers my point.
So insofar as that group is pinned in time to that period, yes, but the claimant doesn't know how many there are.
Sorry, you've just relied on the finding of fact that the claimant only knew of Mr. Amin and no one else.
I say that is a finding of fact in my favour. I don't necessarily.
It's a finding that there was one person
sorry,
other than
yes.
KK.
Yes.
But it's against you in the sense that you seem to be suggesting there was a wide and indeterminate class.
Yeah.
Of the judge's finding of fact, which you positively relied on, it's a class of one.
Yes. The class of one that he knows about is Amin. He does not positively know about others, but this class envisages that there may be others that he doesn't know about and that he wants sorted out going forward. Now, the only reason I say this is because we say that the agreement actually does not preclude third-party use. It doesn't preclude third-party use, and that was the finding of the judge, accepting SS as evidence, that it would preclude franchisees from being, from sub-licensees of any kind.
Is that quite the right question? You start off on this hypothesis with a third party using an infringing sign.
Yes.
So then you have to ask, has that been legitimised in some way? And for that, you need to find some sanction in here, don't you, for that use? And that sanction would presumably come from, well, either 5.6 perhaps in relation to a specific class, or 5.8 in the sense that it's licensing KK to use, and the sense of using being extended to franchise, I suppose.
Use in the course of trade that's the basic form of use from which all use springs. In fact, use by licensees is regarded as being that when it comes to revocation and so on. Yes, I mean, I think we do say that. There's no doubt that, you know, that the parties made this agreement on the basis of the knowledge they had at the time, which there might have been a suspicion that there were other parties out there that were not known, and that it was a limited problem because it was a smaller group. But this clause was relied upon by the judge as precluding franchisees because it was said that all of the franchisees that came along, it might be related to the judge's, to my Lord Justice Falk's, Lady Justice Falk's question, which is that all of the franchisees that came along later.
But can we go back to 5.6, because we haven't yet looked at the second sentence. Because what that says is, if such third parties do not comply, KK will provide reasonable assistance in any legal proceedings brought by MFS against those third parties to enforce the MFF trademarks.
Yes.
So what that is envisaging is that KK will not necessarily be in a position to compel the third parties to use the Metro's signs.
Oh, I would suggest on the contrary. I would suggest that the reason for that is because KK would be a useful party to have enforcing a license agreement or a franchise agreement.
It doesn't say that he will join, still less that he will have a claim.
Well, who will have provide reasonable assistance and cooperation. But in my submission, that does not cut against our submission overall. That is about, again, stopping use of Morley's, which is the primary concern of this agreement, but also replacing, in fact,
the obligation on him in the first sentence is to make reasonable efforts. It's
Yes.
not an absolute requirement.
no, it's not
So
an absolute.
if it was envisaged, as at the date of this agreement, KK would have the power to require these third parties to stop using the signs and to start using Metros instead. How is that this clause consistent with that?
This
Because
clause,
he's only required to make reasonable efforts to procure. There's no
Yeah.
absolute obligation. And it's envisaged that they may not comply, and in those circumstances, his only obligation is to provide reasonable assistance to legal proceedings brought by MFF to enforce the MFF trademarks.
so we can't be sure as to how things were drafted and why it said reasonable efforts. That sounds like the sort of thing that the solicitor would introduce at the last minute to
Yes, but
tame the obligation on its
the-
client.
The thought process
Yeah.
of the drafter is immaterial. What's important is what the words convey to the reasonable reader.
And we would say on that, that if these were strangers to KK, the clause wouldn't be there at all. Because he wouldn't, what would be reasonable efforts for third-party infringers?
But would you accept this? In order for clause 5.8 to have the effect you intend, it's a necessary premise that one concludes from 5.6 that the third parties in question are licensees of KK.
In some form, whether that's a franchise agreement or simply some sort of informal.
So if you accept the premise, the question, that is a necessary premise, the question is, why does one conclude from 5.6 that these people are licensees?
Because of the assumption that underlies 5.6, that KK can procure, or at least exercise reasonable efforts to procure the change and the use of the Metro sign going forward. And that's, we say,
Why so? Why does he not discharge his obligation under this clause by simply trying to persuade someone with whom he has no legal relationship?
that would be the case if this were a sort of formal license agreement. One often sees that kind of term, where a licensee just has to help police the market, just because those are the sorts of obligations that one sees. But this does not have that character. To procure a third party using the signs and to cease within a reasonable period, and the period is short for him to do it, which in my submission implies that he does have powers. These are not talking about strangers. Indeed, the judge didn't interpret this as being strangers to Mr. KK. The judge interpreted it as being people who were irrelevant because they were long ago, or they were effectively at the time of the agreement. And I can see, I can see that the point is somewhat limited by the fact that it is dated, but it is nevertheless, and for a reason I'll come to in a moment, clear under this agreement that any sensible construction has to allow sublicensing. It is not personal to KK.
I mean, I mean, I think this is picking up your argument. So clause 5.6, you say,
Yep.
in the reference to procuring someone to use the Metro's signs, on the face of it, must be contemplating that at least somebody who was already using the name Morley's
Yes. And so
can
one,
in the future use the Metro's sign.
Yes.
And I suppose that could either be on the basis that it's contemplated that KK will license that, or on the basis that it's contemplated that the Metro sign simply won't infringe anyway.
We would say both of those apply. So the agreement envisages that Metro's is okay in substitution for Morley's. That's the basic thrust of the agreement. And secondly, that that right to use, if this is considered as a license agreement, is granted to KK, but that like any trademark right, and he does have the right to apply for trademarks, any sensible construction of that has to take account of sublicensing, because this is not, I mean, even if he set up a business and the business was using the trademark as in one shop, but it was a business, that would require a license from him. So it's obviously right that if it's allowing him to apply for trademarks, then that must be, it must be envisaging something beyond him. And once you move off this notion that the agreement is purely personal, cannot allow sublicensing, and you look at the clauses that do envisage that, or at least hint at that, then it is by far the better view of this contract that it does cover the ability to sublicense. Indeed, the entire agreement says very little about Metro signs at all. And the reason for that is because nobody cared about the Metro
Say
signs.
that, but what about clause 6.3, for example, and indeed 6.5? I mean,
Yeah, well, not to bring proceedings against them. So he got that very clear promise from the claimant. Unless said dealings breach any other term of this agreement, not to threaten or bring proceedings against KK. But what I'm saying is that it was, little is said because it's assumed in this agreement that Metro's is fine. Metro's signs, plural, and any reasonable modifications thereof. I just want to show you 5.8 again. So the parties agree that the undertakings above will not apply to, and KK will be permitted to use in the course of trade the Metro signs, to include, for the avoidance of doubt, the application of the Metro signs to packaging and application for a registered trademark in respect of the Metro signs. And we say, because you've got above that in 5.1 to 5.5, those undertakings do not apply to the Metro signs, and those undertakings are ceasing to use the signs, not to infringe the marks, not to pass off the business, not to apply for a registered trademark containing MFF trademark or any sign confusingly similar to. That doesn't apply to the Metro signs, as we read this agreement. So I think that probably, I don't think there's much more I can say about the position of the franchisees. We say it went without saying, it was obvious that this permitted one.
can I be clear how you put your case, and it may be that you put it on both bases, but one possibility is that you say, as a matter of proper construction of the express terms, they include an ability of KK to license third parties not restricted to those who were previously using the signs as at the effective date to use the Metro signs.
Yes.
The alternative possibility is to be implied to that effect.
I rely on both those bases, and I have to say, not restricted to the relevant date because all my franchisees were later.
Well, right.
Of course,
But insofar as you put it on the basis of an implied term, how do you justify that?
On the basis that the agreement would not be workable if it were personal to KK himself. It's because he's got to use it in the course of trade, and he's an individual, and it's for chicken shops, and so he's going to have businesses.
He, as a person, can run as many chicken
Yes.
shops as he likes.
Yeah, that's right. But he's got to own all those shops, and he's got to use the mark himself in all those shops. When it's perfectly,
But what's the commercial obstacle to
The
a sole
commercial-
trader
yeah, the commercial
owning a number of chicken shops?
because it's much more common, and would go without saying, my submission, that one would have a business that exploits a trademark at the very least, and one would need to license that business.
Sorry, you mean a corporate entity?
Corporate entity, yeah. So he would have to license that
Well,
corporate entity.
Was he in?
Or
he
transfer
wasn't
the-
incorporated at the time. I mean, it raises all sorts of points.
Well, it's true, but what we say is that it's a rare trademark that would be simply personal to an individual. You know, it might exist for some personal services that would be provided, but for these services and goods, these would be the kinds of goods where that would be normal and would commonplace. The second point we say is that there are some certain clauses in this that become unworkable or become strained, at the very least, if there isn't any right to sublicense. I've taken you to those. And so we apply the term that way, but we also, I think, in our skeleton, there's a point about whether we said that the agreement was silent on sublicensing, ultimately, and we're not permitted to run that argument by the judge below. And we've said in our skeleton that we think we ought to be able to rely on it here, if and to the extent it's necessary to do so, because it's simply a point of construction, doesn't require any different evidence that was.
so if you were to approach it as a matter of construction, I suppose you would have to say that the word use in 5.8 is to be understood as extending to franchising, and you would say that's supported by the permission to apply for a trademark, and also the contemplation in 5.6 that at least somebody is going to be using the Metro's sign.
Oh, that's quite right. As you indicate, when you apply for a trademark, you indicate that it's being used by the proprietor or with his consent, or there's a bona fide intention it will be so used. And equally, when it comes to revocation on non-use, use with the consent of the proprietor is also use. So that they go together.
That's on the assumption that there's no use by the proprietor. If there's use by the proprietor, you don't need use by the.
You don't need to, but
consent.
correct, of course, but you don't need to, but you often have both, different periods, or you may have overlapping use.
Sorry, but I thought the argument you were advancing was one of necessity. And what I'm querying is whether the fact that there's registration of a trademark means that it is necessary to read use as extending to use by someone other than the proprietor. First of all, as regards intention to use, as at the date of application for registration, an intention by the proprietor himself to use will be quite sufficient.
Yes.
As regards non-use, use by the proprietor will be quite sufficient to defeat the non-use attack. So why is it necessary that there be use by someone with the consent of the party?
It's rather than necessary, it went without saying, and it was obvious when one looks at the clauses of the agreement overall. It doesn't have to be a necessity test in all circumstances, as I read the case. So I don't think there was any dispute on the case law. But I was specifically addressing the issue of whether the agreement is silent on use by third parties and therefore allows it. I don't think that that's an implied term argument. I suggest that that is simply an agreement. Once you're allowed to use something, you can use it in the way that you see fit. Which I hope was the way that it was put. But I hope that not much turns on it, because we say the express terms of the agreement on a proper construction envisage third-party use, and indeed there was a third party who may or may not have been a franchisee, but certainly a licensee. So that's the first issue that arises out of the agreement. The second issue that arises is whether the sign complained of was consented to under the agreement. Now, this brings in straight into focus. What sign are we talking about? Because as I showed you in the exchange with Justice Arnold, there's a little uncertainty as to how we got to what was called sign 1, but fortunately when the judge is discussing the sign that moved away from Annex A to the settlement agreement, known as the settlement sign, it's pretty clear that she is talking about, well, the sign that's shown in her judgment. I'll just find you. She's got a table of the signs. If you take, actually the best examples are on page 55. That's the analysis that the judge was carrying out in terms of the infringement. You've got the movement from metros with the blue border, then the sort of zoomed in, cropped version. Metros, it's the real taste. But when you...
As I understand it, analytically what's going on here is that the judge has accepted, for the purposes of the trademark infringement analysis, the claimant's characterisation of the sign complaint, which involves, as you rightly say, a cropped view of the patient. But when it comes to considering the defence under the 2018 settlement agreement, what she does is consider the fascia, perhaps not its in entirety, but certainly more of it.
Yes. Now, well, if you look at that part of the judgment...
So in that sense, that's a difference in your client's favour.
Yeah, I guess so. At 96 of her judgment, there's a table of the 3 marks that the judge goes on to consider in this part of the case. You've got the Morley's trademark.
Sorry, I'm in the wrong place.
96, tab 7, says the judgment, page 96.
I see. So I was looking at paragraph 96.
Sorry.
Yeah.
Page 96, above paragraph 146.
Yes.
So there you've got the settlement sign without strapline. You then have sign 1, again, that's coming from the earlier part of the judgment. And then you've got the trademark.
Yeah, so although she reproduces sign 1, visually speaking, from her trademark infringement analysis, you can see from the discussion at 146 and indeed a bit more fully at 155, that she doesn't take that as being the totality of the relevant sign for the purposes of the contractions.
Yes, exactly. And I think I mentioned that there were a number of copies of the sign that the judge must have been talking about, and one can find one at 214 of the supplemental bundle. This is important because looking at the table that I hope you still have open, the cropped sign is perhaps closer, please say not confusingly similar, but still closer than the bordered one. But if you look at 214 of your supplemental bundle, that's the true sign that's being considered so far as reasonable modifications thereto under the settlement agreement. As I understand it, that's what the judge is describing.
Well, I wonder if that's correct, because this is a franchise agreement between KK and one of the other defendants, as I understand it. It doesn't tell us what was actually being used.
We've got pictures as well.
Yeah, you showed us the pictures earlier, and my understanding is that's what the judge had in mind.
Yes, but the pictures don't show the borders and that sort of thing so clearly.
I think they do if you compare tabs 6 and 7. So tab 6 is at night and tab 7 is in the daytime.
Okay.
And just before we leave page 214, the judge says at 146, the electric blue, the remaining borders be dulled down to dark blue. You cannot say that at page 214.
Yes. You can't say that at 214, that's right, and it might just be as an artifact of the printing. But as
you can see it from the pictures.
You can see it from the pictures. So looking at, is it tab 7 that my lady has in mind?
I was on image tab 6.
Tab 6.
So I think I can see no blue at the bottom.
But that's because it's also at night. I mean, even if one looks at the right-hand side, it's quite difficult to say.
Look at the daytime.
The daytime picture on
tab 7. The bottom blue border is plainly absent.
That's the clearest one.
So she's right about that.
Yeah, that's right that the bottom disappeared, and we saw that in the franchise agreements too. I'm not denying that.
Yeah.
So the question is, looking at that, whether that is a reasonable modification of the settlement sign.
Well, indeed, and to be clear, as I understand your ground of appeal here, you don't dispute that the judge has accurately identified the changes in 155. Your contention is that she was wrong to say that those were not reasonable modifications.
Yes. Put simply, that is the position. We say this is, first of all, the words is not just a reasonable modification or subject to it's any reasonable modifications to the metro signs which are defined in the plural. That's the first point.
Just sorry, I haven't thought about the metro signs in the plural. What does metro signs in the plural?
That's the definitional aspect of the agreement. And it's the clause 1, metro signs.
I mean, it says signs, but then it seems to go to Annex A.
Yes, but the logo, a copy of which is included at Annex A, I think the best I can say is it's a little unclear because there's a mismatch between the wording in the definition and what you see in the picture.
Well, doesn't the signs mean the logo plus further reasonable modifications? They are all metro signs.
Yes, that's what I would submit. I would say that does that makes sense of metro signs. The part that I think doesn't make sense is metro fried chicken. Well, those 3 words. One struggles to find them anywhere in the papers, actually. So when it comes to this, the judge, if I could take you to 154, which is the critical paragraph at the time, I know the judge finds that the natural and ordinary meaning of the words reasonable modifications in the context of a license being granted by KK, subject to reasonable modifications there too. It actually doesn't say subject to reasonable modifications, and any reasonable modification, is that KK as licensee may make modifications, but they must be reasonable when viewed through the eyes of the claimant acting reasonably as the licensor. In my judgment, and taking into account that natural and ordinary meaning in the context of this settlement agreement, in which the parties sat down and produced a settlement sign, which neither may have liked, but both were prepared to compromise and live with, in order to settle their trademark dispute and get on with their business, where it's reasonable to assume that their focus was on the settlement sign and the wording of the definition. The reasonable person with all the background knowledge would have understood the parties to be using reasonable modifications to mean modifications which did not increase the similarity of the settlement sign to the Morley's red and
So
white mark.
do you take issue with that test?
Yes, we do. We say, first of all, this was based upon evidence ex post facto given by SS as to what he did.
That's attacking the reasoning
Yeah.
rather than conclusion. Can we start with the conclusion?
The conclusion
you,
is,
you are taking issue with a test that says modifications which don't increase the similarity.
yes,
So you say that's wrong, and you're therefore arguing that it's permissible for the modifications to increase the similarity of settlement sign to the trademark.
yes, yes. It's not to cause confusion on the basis that this sign is remotely far away, that it's not a problem. To take a step closer where it's still not a problem is not
What is the correct test?
the
on your
correct
side?
test. We say, I mean, it's quite difficult to formulate this because I'm not on the contractual part at the time, but one starting point is that it ought to have taken account of both sides' interests. And in
No,
particular,
that's
yeah.
the reasoning for how you get to the result. What I'm asking for you is your submission as to what the result should be. What is the test?
the test is whether the, does my lord mean the test for
The
interfering with the
judge's
judgment?
test is which did not increase the similarity.
Yeah, yeah.
And
That-
what's your alternative
Well,
test?
let me make it clear that I attack that first, that can't be right. I mean, if you imagine.
Got that.
Yeah.
But what I'm
Okay.
waiting for is your alternative.
All right, so we would accept that if the sign causes confusion, if the modifications that are added cause confusion, that would be
Actual confusion?
a likelihood of confusion will do. Although it's a little bit vague, considering this is a settlement agreement where one is trying to put all that behind us, it should be more
So-
specific, but I'll live
So
with that.
the modifications must cause a likelihood of confusion.
Must cause a likelihood of confusion in the mind of the average consumer, but the modifications must, and that's important.
Would you accept that modifications which increased the likelihood of confusions would be called?
Yes, because there's already a likelihood of confusion, so of course I would say that. But there is no likelihood of confusion on the hypothesis of this agreement with metros. That's the point. So if on the, but imagine if the trademark were cattle, just to take a completely different word, and that was the permitted word. And it was in green and white. And what the defendant did was to get that mark up with a very large stylized C, like a bit like the same font as the Morley's. As a matter of logic, that is closer to the, just coming closer to the trademarks. It increases the similarity. That's the deceptiveness of the test, because any increase in the similarity can lead to the agreement falling apart or breach of the agreement. And that can't be right in circumstances where the agreement envisages that metros is fine.
Can I just go back a stage? You say the judge was wrong to look at things exclusively from the point of view of the
Yes,
licensor. You have to take into account the interests of the licensee,
yes. Well, both sides.
or both sides.
It's reasonable, it's an objective
But
test, we would say.
What interest did KK have in making modifications such as we find here, when on the face of it, their only obvious purpose would be to increase the similarity?
Well, we don't agree with that hypothesis. If I could just show you an example. Three-sided blue border versus four-sided blue border, or electric blue versus dull blue. How on earth do those make it closer? But even if you were to say they do, because hypothetically you've got rid of one dimension, one line of border, and a border as a whole as a point of distinction, then if you've got rid of one line, then that's actually a good demonstration of the principle. Strictly speaking, it is closer, because maybe two lines going would be even closer. But that's the problem.
So what interest did KK have in taking away the line or changing the colour that anybody should be worried about?
I think, I mean, I can't speak for him, but so far as his interests are concerned, this provision exists for the purposes of allowing someone who is going to be using the sign in the course of their business to make evolutions in the formation of the sign as their business progresses, and one sees that.
Yeah, I mean, as an approach, that seems to me to be perfectly acceptable. And let's illustrate it by a different example. Suppose KK were to decide to make the words fried chicken the same size as metros.
Yes.
This goes back to your point about the ambiguity of the definition.
Yeah.
Might be said that's a perfectly reasonable modification.
Yes.
And it might be said that that's something he has an interest in doing, to emphasise to his customers that the main product he's selling is fried chicken.
Yeah.
And that would not increase the similarity, would it?
Well, I don't know. It depends it depends on one's view of the overall similarity between the marks. I mean, the judge thought that different words were similar. So it's not for me to say, but it's true that that the defendant's interests would or should not have been to increase similarity in the sense of making it confusingly similar. But in my submission, the changes that have been made clearly are design and marketing choices. I'm not giving evidence here, but in my submission, that is clearly the case. If one looks at the blue background, for example, you see that it seems to, the blue border in that picture seems to be of a sign against a blue wall. And maybe that was why, because if you had a lower border, it didn't stick out or something. It's difficult to say, but perhaps more saliently, what about the slogan? Because that was important to the judge. Right. That was held to be another main feature that was a step closer. When we say it's not enough for it to be a step closer, but just to take that for what it was worth, it's obvious, we say, that a business would want to include a slogan. SS's evidence was that he had no objection to the slogan, to a slogan being used. The complaint was the position of the slogan.
It's not just the position of it, it's the content.
And the content, yes, exactly. So the position and the content of the slogan. Now, I come back to the points I made earlier about this is a chicken shop, this is a food service establishment. It's going to want to exhort the quality of its products. I venture to suggest that any slogan in this sector is going to be referencing the taste of the products, especially fast food. You're not going to reference other qualities, perhaps freshness of ingredients, but that doesn't really apply, in my submission, to some of these sorts of...
Absolutely no need to have the same sort of italicized writing, an ellipsis, and the word taste.
The ellipsis...
Perfectly well have a different slogan.
In my submission, taste is really the only overlap. The ellipsis would not be seen. It's in a completely different... I mean, if one looks at the Morley's one, I don't know if you still have that open,
Well, you can compare, for example.
You don't have
at
the
tab
MMM.
5.
And it's actually not in the same position, as it happens. It's further along the word, but it's the real taste capitalized. It's the same size as fried chicken and burgers, barbecue wings and ribs. These are the fundamental meaning of reasonable modifications and any reasonable modifications is permissive. It's to say you can get on with your business and do things which objectively traders are likely to want to do when they are configuring their trade signage. That, we say, is the biggest interest that would have been protected. So far as the claimant's interests are concerned, as long as you don't cause confusion. But we've already said that Metro's does not cause confusion. That's the thesis of the agreement. And that, in my submission, is actually what this case, put plainly, has really been about. It's been about undoing an agreement that the claimant was not happy with, that it signed up for in order to stop conduct which it regarded as blatantly infringing its rights, justifiably, you might say, but it was the quid pro quo of that agreement that Metros could be used. And these are tweaks in my submission, or the addition of non-distinctive promotional statements that cannot possibly confuse because they don't indicate origin. They wouldn't really be remembered, although it might be said that the slogan of the claimants, the triple M, the MMM, it tastes better, particularly the first letters of that, maybe have a bit of distinctiveness because they echo the large M as a badge of origin. I make no submissions or admissions in that regard, but the certainly this sort of commonplace, routine, mundane expression is not going to be accorded any trademark significance, and it is not going to have a major effect. It's purely, we say, falling within any reasonable modification.
I mean, at this point, we're not concerned, are we, with trademark significance? We're concerned with whether contractually it's a reasonable modification.
We might be.
Well,
We might, because
yes,
it causing
I'm
confusion, it
going
would be.
to ask,
Yeah.
your test is whether it increases likelihood of confusion.
No, whether it causes.
Causes or
Yes, it's
increases.
got to have it's got to have some effect.
But then you say, in fact, there's no likelihood of confusion, and that's sort of baked into the settlement
Yeah.
agreement. So I'm having trouble with your test.
So
If it's right that
Yeah.
effectively the parties have agreed that there is no likelihood of confusion with the settlement side,
yes.
what test are you saying should be applied?
Well, there's nothing in the agreement that suggests that Metros is close to the line and needs to be watched carefully. That's the point. So if you hypothesize Metros as being a sign that is permissible and acceptable on all sides, it's not difficult to see how that test, a test of any appreciable difference that could be said to make it more similar, I mean, apart from anything, it's a very, very vague test as well, because perhaps practically any change could be said to be that, because of the
Now, I
work.
understand, but I'm trying to understand what you say is
Yeah.
the test.
So
And you refer to causing or increasing.
It's got to be, yes, it's got to be causative of a likelihood of confusion. The change has to be. Because otherwise, and that's what has been argued in this case, any alteration, no matter how small, results in the reactivation of an argument that the claimant has abandoned, which is that Metros is confusingly similar. If you take the view that Metros is similar to Morley's, then practically any change, apart from, as my Lord Justice Arnold put it to me, changes in the other direction, right, to make it less close. Obviously, those would not. If you put a big blue, whatever, a big blue globe in the background or something, it might make it even less close. But the point is, this is not only analysed from the perspective of the claimant. It's principally, we say, but certainly I'll live with equally, to be viewed from the perspective of the party that needs to make the modifications. So things such as necessity would come into it. Maybe they change their address. Maybe they change their logo a little bit. They change the font. Let's say they decide to put it in a Gothic font or something like that. Then that would be normal, reasonable modifications, because it's about allowing them to do so. It doesn't contain a test in the end, and the judge, we say, imposed a test that was unilateral and was placed onto the contract by SS himself, ex post facto, because it suited him to argue that at trial. And whilst it may be right in a lot of cases, it's not right in this case, because the hypothesis of the agreement is that this is not a problem. So you can't suddenly turn this into a problem by any change, we would say. Let me just check my notes. Those are the main grounds.
You covered all the grounds except ground A.
Yeah. My learned friend, my learned junior, Ms. Watkinson, proposes to follow on that point. Yeah. Did you, perhaps could you do so after lunch, if that's suitable? Or
Not sure why we shouldn't make a start. Incidentally, Miss Watkinson, I know that you've got a back issue, so you're very welcome to stay seated if that suits you better.
No, my lord, I would like to stand.
Yes. I think let's make a start so we use the last 5 minutes or so.
yes, of course. What this box or the letter? Yeah.
Good afternoon, my lords, my lady. As indicated by my learned leader, I will be addressing the 8th and final ground of appeal. This ground of appeal is addressed at paragraphs 51 to 56 of the appellant's skeleton argument, which is contained in tab 4, pages 35 to 36 of the core bundle. By way of background to the finding upon which this ground is based, it was alleged by the claimant at trial that the 6th and 7th defendants had infringed what is known as the triple M mark, which is a word mark, contrary to section 10(2)(b) of the Trademarks Act, by way of their use of sign 2, which consists of the letter M repeated 3 times, essentially, in relation to burgers on menu boards which appeared within the respective Metro stores. It was
a foundational question on this issue, because
Yes, my lord.
I was reading both the grounds of appeal and the skeleton argument. It seemed to me that the other side's position was a little ambiguous in this respect. The judge proceeds on the basis that sign 2 is 3 capital less rounds. And that doesn't seem to have been disputed before the judge, that was an accurate characterization of what the sign was. And then there's, of course, the issue of the extent to which that is similar to the triple M mark. And I fully appreciate that you are most definitely challenging the judge's conclusion on similarity. But what I couldn't quite work out is whether you are challenging the judge's identification of the sign, and if so, upon what basis?
My lord, we don't dispute the finding of the judge in relation to the identification of the sign as sign 2. I think the point, which obviously I'll come on to address you on, is the way in which that sign would be viewed and orally pronounced. So that's what the ground of appeal essentially is.
So it is the comparison between Triple M and MMF.
On the notice,
My lord, if I may just take you to the notice for itself. So this is at, you can see it in the judgment behind tab 7, page 89. So it's just under the heading issue 7 is signed to you similar to the Triple M mark. And I appreciate it's rather difficult for one to see what it actually says.
Yeah, so that shows us the context of
Yeah.
the use.
Yeah. So the sign which is alleged to infringe, well, which was found to infringe, was the MMM. Does that answer your lordship's question?
Yeah. So you don't dispute the identification of the sign, but you point out that the context of the use was as shown there.
So, my lord, may you repeat the last part of
You
that
point
sentence?
out that the context of the use of the sign was as we see in the photograph.
Yes, if I may just ask your lordships and your ladyships turn to the Trademarks Act itself,
So that's volume 2, isn't it?
volume 2 of the Authorities Bundle, tab 22, I believe.
So are we in section 10? I
Yes.
think that's the only
my-
bit we've got in the bundle, so it's it seems a safe bet we're in section 10. Yes.
Yes, section 10, 2B.
Yes.
Now, obviously, I appreciate that the court's familiar with this part of the law, but there is something I do just wish to bring to the court's attention, for purposes which I hope will become clear later on in my submissions. Now, 10.2b states a person infringes a registered trademark if he uses in the course of trade a sign where, because the sign is similar to the trademark and is used in relation to the goods or services, identical with or similar to those for which the trademark is registered, there exists a likelihood of confusion on the part of the public, which includes the likelihood of confusion, which includes the likelihood of association with the trademark. Now, the part of the law which I wish to draw to the court's attention, is if he uses in the course of trade. Now, I will park that for the moment and come back to that during the course of my submissions, but in the interest of following a structure, I thought it helpful to go to the law as the first point of call.
And is that going to be a convenient moment to break?
Yes.
So 2 o'clock.